So I have the privilege to introduce our guest speaker today in our talk, Asian American Advocacy at the Courts, under 12 years after Juhua versus Williamson. Dr. Ameet Sarpatwari is a professor at Harvard Medical School and the assistant director of Portal, the program on regulation, therapeutics, and law, got that right, at the Brigham and Women's Hospital. And most importantly, he is the professor of a highly rated course on public health law at the Harvard T.H. Chan School of Public Health, which I am taking. Full disclosure, my final exam has not been graded yet, so I do have to say certain things, but I'm thrilled to have Professor Sarpatwari with us here today, especially during this time of transition and major upheaval in the Supreme Court. So without further ado, Professor, please go ahead and take it over.
Sounds great. Thank you so much, Brandon. Just making sure you guys can hear me okay?
Cool.
Yeah, can you hear me? Okay, great. Thank you so much. So yes, as Brandon mentioned, it's been a delight to have him in my public health law class. And what I'm hoping today is to go through a few matters. I'll put up my slides in just a second, but first thing I want to say is I hope this can be as interactive as possible. So feel free to pose any comments, questions in the chat. Hopefully Brandon can monitor that and interject as needed. And otherwise, feel free to raise your hand and I can definitely call on you. So with that, I think, Brandon, we're still going to have a few people coming in through the waiting room. We have somebody else who can help admit them. Okay, fantastic. So let me put up my slides and get into this then. So it was a real pleasure and honor to be invited to give a little bit of remarks on public health law, specifically focusing on Asian American advocacy at the court. And one of the cases, the primary case we'll focus on today, is central, I think, to the development of constitutional law in this country and the concept of not only what limits there are on states' power, but on equal protection of the law. And so we'll jump into that in just a second. So here's just a quick agenda of what I hope to cover. A little bit just about my work, teaching, disclosures, and then really focusing in on the principles of public health law, some of the tensions underlying them and the missteps that have been conducted under the auspices or under the name of public health law, and then focus a little bit on the specific issue pertaining to Juhua. So talk about 19th century Chinese immigration and discrimination, this case Juhua versus Williamson, what it brought about, and what we are dealing with right now, just particularly in light of COVID, about Asian American public health today. So that I want to leave a little bit of time for Q&A, particularly as I know you guys will have questions about what the court is currently doing. It's a bit of reading tea leaves, but I think I have the ability to read a little bit of them. And so I hope you will feel free to ask any questions on your mind related to any public health issues before the court right now. So with that being said, as Brandon mentioned, I'm an assistant professor at Brigham and Women's Hospital and Harvard Medical School, and the assistant director of Portal, the program on regulation, therapeutics, and law. In addition, at the Harvard T.H. Chan School of Public Health, I am now the faculty director of the JDMPH program. And much of my research focuses on the effects and laws and regulations on therapeutic development, approval, use, and related public health outcomes. And I have the pleasure of teaching public health law at the School of Public Health, but also we've developed an open online access course, an edX course on prescription drug regulation, cost, and access, which is recycles every sort of few months. It's an 8-week course. You can take it at your own pace, but it is starting anew, I guess, this weekend. So the timing is good. Just a little bit on my disclosures about who my funding is and what other sources of potential conflicts I have. But that being said, want to get into a little bit about what we mean by public health law. So what we're really talking about is the study of the legal powers and duties of the state to assure the conditions for people to be healthy, and then the limitations on the power of the state to constrain for the common good, the autonomy, privacy, liberty, proprietary, and other legally protected interests of individuals. So really, on one hand, you've got what can the state, and here we're talking about both in the context of the United States, we're talking about the federal government and the smaller states, Massachusetts, Maine. What powers do they have to promote public health? What are the levers that are there, and what are the limitations on those levers? And particularly in thinking about this issue, there is a tension, and it's a philosophical tension between what is the right course of action from a moral standpoint. And that involves really thinking about what underlies public health. And there is a strong utilitarian bend to public health, which is we need to do that which produces the greatest good for the greatest number. So when we're talking about population health and dealing with scarce resources, let's make sure we put those that yield the greatest dividend. And so that's a very consequentialist attitude. But within that, there is also a strong deontological streak. So we want to make sure that we are also not just thinking about ends, but thinking about treating individuals as ends in themselves, not means to ends. And so in doing so, we need to treat individuals with respect as autonomous decision makers. And we want to make sure that we're not infringing on their liberties and their rights. And doing so is not easy when we are trying to promote public health. And so the real question is, when we're talking about the carrots and the sticks that the state can employ, we need to make sure we're doing so in an ethical way. And that is, always front of mind for any policymaker in public health. And so more broadly speaking, what we're thinking about and sort of the big questions in public health law are what powers does the government have to act in the interest of public health? How are these allocated between the different government units? So states and the federal government have a different set of powers. States have this power that's called the police power, which is this general sort of reservoir, a deep well, which they can draw upon to promote the general welfare. Whereas the federal government is one of limited powers. So anything that it can do has to be a specifically enumerated power in the Constitution. What rights do individuals have to be protected from coercive government measure, and what are the sources of these rights? When we talk about this, oftentimes, at least in my class and in this lecture, we'll be talking about constitutional rights from the federal constitution, but there's state constitutional rights as well. There's also statutory and regulatory rights, so statutory rights that legislative bodies promote, regulatory rights that agencies may promulgate. And it's important to know what those are and what happens when there is friction. How will courts evaluate that? So how do we go about balancing government interests and individual rights? And what processes can we use to evaluate public policies? That really goes to the heart of public health law. So for this audience of soon-to-be clinicians, these are all ideas to think about in the back of your head as you sort of contemplate, well, if I am very passionate about public health, how can we go about improving it in a way that is within the remit of these government powers, but also is respectful of the rights that are protected, that protect individuals within society. So where I want to start is just to talk a little bit about a canonical case, Jacobson versus Massachusetts. And the reason I want to bring this up is to talk a little bit about So first, the origins of public health power and what the court has deemed this power to be, but also to talk about the missteps that we've done. And so particularly when we're thinking about Asian American public health, it's important to recognize that among a wider set of minorities within the US, public health has often been an instrument of uh, I guess harm is the best way to put it. And so understanding that history is key to understanding not only Juhua, but understanding why there is a significant degree of distrust in public health institutions right now, and how that distrust has been exploited by certain politicians in the era of COVID. So to start with, well, this is a case that takes place in Massachusetts. Um, and this is at the turn of the century. There's a smallpox outbreak in Cambridge. And pursuant to a Massachusetts state law, the Cambridge Board of Public Health is asking, or not asking in this case, is using its powers to require vaccination of all inhabitants who have not been vaccinated in the past 5 years. So there is an exception for children who are unfit for vaccination. Vaccination is provided free of cost, and there's a penalty of $5. Now, calculating that to today's money, we're talking less than $200, but still, a decent penalty for not getting vaccinated. And there was an individual, and this all builds in within a wider movement within society. So there's always been a strong anti-vaccination movement in the U.S. But there was a Reverend Henning Jacobson who refused, and he pled guilty. And part of his refusal was based on religious principles, but at the time, the First Amendment actually didn't apply to the states yet. It only applied to the federal government. So that wasn't really the big issue here. But he also argued that this order by the Cambridge Board of Public Health, by the Cambridge Board of Health, exceeded the police power of the state. And he had another issue, which is that he said in a prior time as a child when he had been vaccinated, he had experienced significant side effects. So he's saying it was actually unsafe for him to get vaccinated. This question sort of worked its way through the courts, through the state court system, and then ultimately up to the Supreme Court. And the real question here was whether the vaccinations provided under the revised laws of Massachusetts contravene the rights afforded to Jacobson under the US Constitution. So he was arguing that there are certain rights in the Constitution that really protect him from compulsory vaccination. And when the states, when the court heard this, what they ultimately did was to affirm the highest court in Massachusetts, the Massachusetts Supreme Judicial Court. They affirmed the decision of that state court and said that this was legitimately within the power of the state of Massachusetts, and there was nothing that violated the Constitution with this compulsory order. And here are some key limitations in terms of understanding the scope of this police power. So the court said the liberty secured by the Constitution of the United States to every person within the jurisdiction does not import an absolute right in each person at all times and in all circumstances to be wholly free from restraint. So in terms of what liberty individuals have, there is a limit on that. And according to settled principles, the police power of a state must be held to embrace at least such reasonable regulations established directly by legislative enactment as will protect the public health and the public safety. And so they evaluated the law that would require, or that gave the Board of Public Health the ability to impose mandatory vaccination, and said this was perfectly within the scope of the state's police power. they said the risk of in terms of the risk of vaccination, they were very deferential and dismissive. They said the Massachusetts legislature chose between competing theories, and that really an occasional injury from a vaccine is insufficient to say that this is on the whole unsafe for individuals. So the bottom line here is that there is a huge police power that the states can rely upon to promote public health. And in doing so, courts will be very deferential to the state. And so that's a particularly a good thing and a bad thing from the standpoint of public health. It allows the state a lot of leeway to promote public health, but at the same time, in terms of the possible misuse of that power, we have to be on guard about. And what the court is saying here is we're not going to be actively policing these missteps, as long as there is a reasonable relation to a legitimate interest that the state is pursuing. This is going to be okay. So there is no fundamental right to bodily autonomy, to refusal of treatment, and the state was within its powers to compel vaccination and to fine Jacobson for not being vaccinated. So what happened? And the underlying story here is what I want to focus on, particularly in context to the case of Juhua, which is, this is the story. So on March 15th, 1902, Boston public health doctors accompanied by guards descended on the railway yards and forcibly vaccinated Italians, Negroes, and other employees. So who is the state going after? Well, they're rounding up the usual minority suspect groups. And you see similar sort of actions, and I'd say missteps in the name of public health that we'll talk about one case in particular, but sterilization campaigns, things like urban renewal, which all have the potential effect of really either injuring or displacing particular minority populations in the country. And so I thought that this quote in a book review that was published in the Harvard Law Review was quite apt, which is when we think about public health, our thesis is that claims to protect the public's health frequently have served as proxies for bias, discrimination, and nativism. Many people of color and vulnerable minority groups have been caused great harm in the name of advancing and protecting the public's health. Unfortunately, during such periods in American history, courts too have failed to protect basic civil liberties, and people have suffered as a result. So I think that is always something that any modern day practitioner of public health needs to keep in mind. What is either the unintended or perhaps the unconscious direct effects of our actions for people who don't have good recourse to the political system, for people who are at the margins of society. And so, with this in mind, I want to turn to the most infamous case, perhaps in public health law in the United States, which is a case Buck versus Bell in 1927. So we're jumping forward a little bit in time, but there's a nice series here and it's hyperlinked. And so Brandon can distribute the slides later, but we're not going to go into it now. But if you want to learn more about this case, you can definitely watch this video. But to give you a brief overview, Carrie Buck is age 17. She is committed to the Virginia Colony for the Epileptic and Feeble-Minded. And according to the court's records, so the factual record that the court is seeing, she is someone who has been deemed a middle grade moron, morally delinquent, and morally delinquent because she had a child out of wedlock. But the context of that is she was actually raped by a nephew of her foster parents. So she was in already a pretty bad situation in terms of foster parents who were not taking good care of her. She ends up being raped and then ends up being labeled somebody who's morally delinquent. So in reviewing her case, the Virginia colony for the epileptic and feeble-minded came to this conclusion that she was the probable potential parent of socially inadequate offspring. Her mother had been committed, had allegedly engaged in prostitution. So this colony was concerned that her offspring would fall down a similar path, even though there was no real similar path at all. And it's important to recognize this is sort of at the height of the US eugenics movement. And Virginia had passed a sterilization law, and the colony wanted to sterilize buck. And so the question that ultimately comes before the court, the Supreme Court, is did the Virginia statute violate buck's due process and equal protection rights under the US Constitution? And so here, let me just step back and say the Constitution affords certain rights to individuals, most notably the Bill of Rights, the first 10 amendments to the Constitution. And of those, in particularly in public health, due process, not just the procedure, which you would think of in due process, there's also a substantive elements of due process, that there are certain fundamental rights that individuals have vis-a-vis the government. And after the era of Reconstruction and passage of the 14th Amendment, these constitutional rights were slowly incorporated in a way that allowed you protection not only against the federal government, but against state governments as well. And so there's this concept of certain fundamental rights, and that is the same. One fundamental right is the right to privacy, which is currently under threat by the Supreme Court right now. And another fundamental right is equal protection. The concept of what equal protection means is pivotal in the Juhua case. But in this context, let's take a look at this notion of substantive due process, these sort of fundamental rights that individuals have, and separately equal protection. Whether or not what the state is seeking to do here violates Buck's equal protection rights. And in a very dark legacy of the Supreme Court, the court rules 8-1, affirming the Supreme Court of Virginia's decision to uphold the law. So it says that the Virginia sterilization law is okay, and its application in this particular instance is also okay. And perhaps the most infamous lines from this case, in an opinion written by Justice Oliver Wendell Holmes, son of the former dean of Harvard Medical School, a famed jurist, perhaps his worst opinion. It is better for all the world if, instead of waiting to execute degenerate offspring for crime, or to let them starve for their imbecility, society can prevent those who are manifestly unfit from continuing their kind. The principle that sustains compulsory vaccination is broad enough to cover cutting the fallopian tubes. 3 generations of imbeciles are enough. So what is oftentimes carried forward in any public health law taught across the country is this notion of a period of time in which this concept, 3 generations of imbeciles are enough, sort of as the dangers of really granting the state wide authority and not treating individuals as ends and not means towards an end. This decision was actually never overturned. It's definitely not good law now, but interestingly, you see how they reference Jacobson in this decision. They say the principle that sustains compulsory vaccination from Jacobson is broad enough to cover cutting the fallopian tubes. So again, referencing this very large police power that states have to rely upon to promote broadly the general welfare, and what the general welfare is really, in some respects, the prerogative of the state. So now, with those cases in mind, and realizing that those cases are a little bit forward in time from what we're going to talk about with Juhua, I want to get into a little bit of just the background of 19th century Chinese immigration, because I think this is critical to understand what the dynamic was like at the time of the Juhua case in San Francisco. So you had a serious drivers of Chinese immigration in the late 19th century. And that started with the California Gold Rush, continued with the building of the Transcontinental Railroad, and also in terms of labor needed for agriculture. And so here you can see in terms of people mining for gold, both what seems to be Caucasian Americans and Chinese Americans in this one picture. And you can see in this table, in terms of specifically California, in 1850, you had 660 people of Chinese nationality immigrate into California, and 1860, that number had jumped to 35,000, and by 1870, it was 50,000. So in the context of other foreign-born groups in California, there was a large influx of Chinese people of Chinese ethnicity. And at first, with plenty of opportunity in the state, this was not an issue. But as the economy soured, there was more of an, I guess, what typically happens in these types of settings, more frustration building within society, more desire to blame a particular group, and usually the blaming of the other that occurs. So this hostility ended up taking a very xenophobic, a very nationalistic frame, and a lot of that was directed against Chinese Americans. And so what you had is, a considerable degree of racism and xenophobia. And one area in which this was sort of used as a weapon was in the notion that this was a period of, it was unfavorably upon drug use, and the notion that there were opium dens in California, the notion that the vehicle for addiction was being somehow spread through from Chinese populations to white populations in the country, was a prevalent sort of source of driving up anti-immigration sentiment. And so I think important to take a look at these two pictures and really not flinch from, again, a very dark history in US history. But figure one, this cartoon, which ran in a September 1881 issue of Harper's Weekly, made visible the hidden truth behind the degradation of white male opium use by foregrounding the image of an opium den patronized by rough-looking bunch of whites over a network of decidedly Orientalist image. It suggested that the truth behind the appearance of white opium use was unequivocally Oriental. In this next figure, you can sort of see a contrast. This is sort of a contrast of you've got Chinese Americans here, and you can see crowded living conditions. You can actually even see this racist depiction of eating of rats, and contrast that with a white laborer returning from home in a very wholesome setup. As his children welcome him home. In fact, if you take a look at our professional organizations at the time, you've got, very horrendous quotes. And here's another one: if the Chinaman cannot get along without his dope, we can get along without him, from the American Pharmaceutical Association in 1902. So within this, there was a buildup of a very large anti-immigration effort, and this led to the Chinese Exclusion Act in 1882. That led to a 10-year ban on labor immigration from China, prohibited citizenship to immigrants who were already in the US, and required certification for re-entry for immigrants who were lawfully in the US and for some reason needed to leave the country and then sought to re-enter the country. The Chinese Exclusion Act was extended a decade later by the Geary Act and made permanent in 1902. And in 1924, remember the Chinese Exclusion Act was passed in 1882, the Immigration Act set quotas based on an 1890 census. So at a time in which immigration was already restricted from largely Asian populations, this continued to restrict Chinese immigration and more broadly, Asian immigration until really the 1960s. And so here you just have a figure of how Chinese immigration fell with passage of the act, and then a little bit of a rise of Japanese immigration and in the early 20th century, but again, that falling to virtually nothing by the 1920s. So with this, we are now into talking about Juhua. And the case of Juhua versus Williamson, 1900, it's not before the Supreme Court. It's actually before a district federal court in California. And the issue really concerns, first of all, whether or not the bubonic plague actually exists in San Francisco at the time. There were allegedly 9 deaths from the plague, which the state, and by the state I mean the city and the public health boards within the city are claiming. But there is an extensive record that is brought forward in this case to, I would say, demonstrate pretty conclusively, but at least show that the evidence that there is the plague actively circulating within San Francisco is very minimal. And in fact, there is a good wealth of evidence suggesting it is not the plague. Either way, the state took action and it quarantined 10 to 12 blocks. Now, think about what quarantine from a public health perspective should and mean. You're trying to limit potentially exposed people into a small space so that they do not circulate the virus or the bacteria or whatever infectious agent you're talking about to other people. In this case, we basically quarantined almost a mini city here. And in this quarantine, we've allowed no restriction. We placed no restriction on movement within the quarantine zone. Not only that, the facts clearly demonstrate that overwhelmingly, this quarantine is only applied against Chinese Americans in the zone. So of the white people who are living in this area, they are permitted to exit and enter. They are permitted to have doctors come into to see them, whereas in both cases, that is not the case for Chinese Americans. Juhua is a grocery store owner, and he brings suit for himself and those similarly situated. And the question that is brought forward in this case is, did enforcement of the quarantine exceed the state's police power or violate Juhua's equal protection rights under the Constitution? So again, we have seen in Jacobson, again, and in Buck, that the state's police power is pretty vast. It really needs to demonstrate a legitimate interest and a rational relationship with what its action is to a legitimate interest to say for a court to say, okay, state, you can go ahead and do this. So in theory, if there was the plague in San Francisco, the question is quarantining 10 to 12 blocks comprising 10,000 people rationally related to stopping the plague from spreading? And the judge in this case really, I guess it's fair to say, rips the government in half in terms of dissecting the argument. And so in terms of the description of the police power, starts by saying, look, again, this court will uphold any reasonable regulation that may be imposed for the purpose of the protection of the people of the city from the invasion of epidemic disease. Now we get to the sort of assessment of whether or not the police power, its use in this instance was justified. And so as to the necessity pertaining to the public health problem, the court says it is the duty of the court to leave such questions to be determined primarily by the authority competent for that purpose. So it dodges here. It does an interesting thing where it sort of goes through an exhaustive record saying, where the judge is basically saying, I don't believe the plague actually ever existed. But in fact, you had here some evidence from the state saying it existed. We're going to defer to the state and assume in this instance that let's say that there was a public health problem that needed the state to intervene. Now the question is, what is the reasonableness of this quarantine? And essentially the court says this is so irrational, so arbitrary, so non-evidence-based as to essentially be lighting a match to hay, is the sort of analogy here, is if you were trying to control the spread of the plague in San Francisco, this was the exact opposite action of what you wanted to do. If we are to suppose that this bubonic plague has existed in San Francisco since the 6th day of March, and that there's been the danger of it spreading over the city, the most dangerous thing that we could have done was to quarantine the whole city as to the Chinese, which was substantially done in the first instance. The next most dangerous thing to do was to quarantine any considerable portion of the city and not restrict intercommunication within the quarantine district. The court actually says on this ground alone, this is one of the very rare exceptions of the use of a police power that doesn't itself infringe a fundamental right. And this is a quarantine, and quarantines are standardly used. But because of the way this quarantine is used, it makes no sense. And the court says this exceeds the state's police power. It is unconstitutional on this ground alone. But the court goes further, and it discusses the concept of equal protection afforded under the Constitution. So pertaining to the application of the quarantine. And what the court says is, in the case at bar, assuming that the Board of Supervisors had just grounds for quarantining the district which had been described, it seems that the Board of Health, in executing the ordinance, left out certain persons, members of other races other than Chinese. This is precisely the point noticed by the Supreme Court of the United States, namely the administration of the law with an evil eye and unequal hand. And so this concept of, particularly on the basis of race or ethnicity, treating people differently, and if it rises to the level of intentional mistreatment, so treatment with an evil eye and an unequal hand, that is essentially going to be a violation of those people's constitutional rights. Now, there is certain instances, and most infamously, Korematsu is a case where allegedly, and well, not allegedly, this is actually what happened, what happens in this instance where somebody's equal protection rights are infringed and they are what's called a suspect class, or where somebody's fundamental rights are infringed, it doesn't automatically mean that the state's actions are not valid. It means that the state has to pass a much higher test, and we call that strict scrutiny, which is usually fatal. And in rare instances, strict scrutiny can actually be sustained and a state can proceed with its action. But typically, at this point, where you have an evil eye and unequal hand, it's going to be a large uphill battle for a state to say that its actions are constitutional. And in fact, what the court is saying here is the state's actions are unconstitutional. There is no justification for this treatment of the Chinese American population with an evil eye and unequal hand. And interestingly, when the court cites precedent here, so again, this is not the Supreme Court in this Juhua case, but it cites the Supreme Court precedent, an earlier case from 1886, which is Yuxing versus Hopkins. And again, in San Francisco, where a San Francisco ordinance made it illegal to operate a laundry in a wooden building without a permit. So what's the rationale? Well, operating a laundry in a wooden building without a permit at the time, it's a fire hazard. We want to make sure that there's certain safeguards to operate that type of enterprise. Now, ostensibly on its face, that sounds okay, but permits were issued to non-Chinese owners, but not at all, not even a single permit to a Chinese owner of laundromat in San Francisco. So it was facially neutral, but discriminatorily as applied. And what the Supreme Court said, where that line of an evil eye and unequal hand comes from, is from this case. Though the law itself be fair on its face and impartial in appearance, yet if it is applied and administered by public authority with an evil eye and unequal hand, so as to practically to make unjust and illegal discriminations between persons in similar circumstances material to their rights, the denial of equal justice is still within the prohibition of the Constitution. So these two cases, Yuxing and Juhua, really stand out in public health law as setting up a powerful principle of equal protection. Now, unfortunately, since this idea of what discriminatory intent means and how you prove it has become a very high bar, but still within the jurisprudence of US laws, this is a very important moment in the history of the country. And so I want to stop for just 1 second and play a little clip. So Brandon, I know time is a little bit, since we started 10 minutes late, can we go 10 minutes over or not really?
I'm checking. Yeah, that's okay. I got permission.
Okay. Thanks. So what I want to do here is to just play a little clip, which I think crystallizes this. And again, I think this is another great sort of documentary that you hopefully can check out on your own time. But I want to play 2 small clips from this. And so at first, actually, let me just pause for 1 second and make sure I'm sharing the right thing. So, okay. Can you guys see this? Okay, great. And just let me know if you can hear it as well, which is usually the problem with Zoom. So I'm going to turn up the volume and...
The solitary arm of the unfinished Statue of Liberty had languished on Madison Square, New York, for more than 5 years. When on May 6, 1882, on the eve of the greatest wave of immigration in American history, President Chester A. Arthur signed into law an extraordinary piece of federal legislation. It was called the Chinese Exclusion Act, and it was unlike any law enacted since the founding of the Republic. Singling out as never before a specific race and nationality for exclusion, it it made it illegal for Chinese workers to come to America, and for Chinese nationals already here ever to become citizens of the United States. Fueled by deep-seated tensions over race and class and national identity that had been festering since the founding of the Republic, it was the first in a long line of acts targeting the Chinese for exclusion, and it would remain in force for more than 60 years. It continues to shape the debate about what it means to be an American to this day.
Okay.
Who were different.
Many people think of this exclusion law as being very racist, very unfair. But if you look at the world at that time, every country was like that, and almost every ethnicity. Try to be a citizen of China or try to be a citizen of Japan is impossible unless you're ethnically Chinese or Japanese. But this is a group of people, Chinese American, the Chinese that were here, who actually fought back and made America better than what it was and helped make America what it is today, the values that we have, including equal protection under the law, rights to education, what it means to be American, what makes you American, to be born here. All these weren't defined.
The 1882 exclusion law.
So let me stop sharing and bring up my screen again. Okay. And so I think these were, sorry, let me just go back. Hopefully you can see the slides again. These are just some reflections from class, which I thought are applicable, even if giving a public talk about this, which is, you know, what would have happened in this instance had the first cases of COVID not been among a primarily white population in the United States? Would the CDC have immediately jumped towards more aggressive containment measures? How would President Trump at the time and other high-ranking officials impacted these decisions? Could we have seen something similar to the Juhua case happen in 2020 America? I think relevant to think about. And so, you know, the tale of 20th century Asian American immigration can be told, I guess, very quickly in these four figures. But you can sort of see with 1960 and onward, you start having an influx of Asian American immigrants again in this country. And around that same time, if you're looking at the principal areas in which people are coming from, you see that Southeastern Asia, Eastern Asia are sort of at the top of the list, and South Central Asia and Western Asia are a little bit lower, but South Central Asia quickly climbs to the level of Eastern Asia and Southeastern Asia. Those are census related terms, by the way. So if you're taking a look then about the heterogeneity of the Asian American population, it's important to realize that, you know, a lot of times Asian Americans are held up as model minorities, but, you know, understanding the public health needs of these populations, the real differences that exist, this isn't a monolith by any means, and a wide range of sort of socioeconomic health within each of these populations. So here you're looking at the median annual household income, $60,000 in the US. If you were factoring Asians as a whole, that's a little bit higher, rises to about $86,000. But then you see this spread between Burmese Americans and Indian Americans, which is, you know, that spread itself is almost $70,000. In terms of who lives in poverty, if you're looking at all Asians, that's 10%, 3% lower than the overall population. But if you take a look at specific groups, the Indian Americans at 6%, Mongolian Americans at 25%. So huge differences, not particularly helpful in some respects to look at this as one whole uniform group, but understanding that there are specific needs within specific segments of this population is particularly important. And then if you look at the origin groups that make up 85% of all Asian Americans, it's largely Chinese, Indian, Filipino, Vietnamese, Korean, and Japanese Americans. So, with this in mind, I just want to give a little mention to, are we meeting the health needs of the Asian American population, particularly in the time of COVID? And I think Brandon has done some nice work in particular here. So again, this is, it's sad to think that this is from April 3rd, 2022, less than, a little bit more than a month from today. Obviously, that number has exceeded 1 million now. And if you're taking a look at the death by age group, so you can see that disproportionately the deaths are happening in elderly populations. There's no real surprise there. Now, here's, depending on the way you look at these figures and what figures you're looking at, they can tell different stories. So if we're taking a look at the percentage of cases and the percentage of the US population, so in each figure, the gray is the percentage of the US population, and the percentage of cases of COVID here are represented by red, and the percentage of deaths are represented by blue. You would think that Asian non-Hispanics are doing quite well in terms of how bad COVID-19 has affected the population. And again, the age-adjusted risk of hospitalizations and death compared to white people, you see that in terms of Asian, it's really a bad figure in terms of the amount of blues that they're using and the different hues. But you can see that this right next to the white reference group, it seems to be a lower overall age-adjusted risk. But I think that this paper that Brandon published is important to realize, and the abstract I'll just read from, because I think it shows that there are needs that are not being met. So we find that while Asian Americans make up a small proportion of COVID deaths in the USA, so you saw that in the last graph, they experience significantly higher excess all-cause mortality, 3.1 times higher, case fatality rate as high as 53% higher, and percentage of deaths attributed to COVID-19 2.1 times higher compared to non-Hispanic whites. So mounting evidence suggests that the disproportionately low testing rates, greater disease severity at care presentation, socioeconomic factors, and racial discrimination contribute to the observed disparities. Improving data reporting and uniformly confronting racism are key components to address health inequities facing communities of color. So, I'm not going to go into, and haven't prepared slides on the uptick in violence against Asian Americans during this time, but it is a serious public health problem in its own right. But that feeds into, I think, this issue of nativism, xenophobia, racism in general, that has contributed to a sort of climate of fear. Whereas a lot of attention can be, is and rightfully put on different minorities in the United States, recognizing that there is a public health problem in terms of violence against Asian Americans, but also COVID disparities in this population is something I think you as an organization have an important opportunity to tackle and to figure out solutions for. And those solutions are not going to be small term, but they can be in, but that they can definitely the roots of those and the seeds of those can be planted right now. And so hopefully that's been a little bit of a run through public health law, and specifically focusing on the Juhua case, and has been informative, but always happy to discuss and take more questions. So I am now at 1:05. I know you guys have other meetings, but happy to spend a little bit of time in Q&A if you'd like.